Right, so this video is going to get into the 8.3, the other amendments, 4, 5, 6, 8, and then I'll finish with 2. But before we look at that, 8.2 looked at the First Amendment and kind of taking it back all the way to our first video. Each of the freedoms of the First Amendment, speech, press, assembly, religion, establishment of religion, all of these things were incorporated over time, and you can see the dates. It wasn't even until the 20th century that freedom of speech was incorporated to the federal government. So what that means is up until 1925, if a state wanted to take away a citizen's freedom of speech, technically they could have, right? And we'll see with the other amendments here, so Sixth Amendment, Fourth Amendment, you'll see a lot of these other ones, the non-yellow colors, a lot of these are incorporated as well, and you can see the different court cases. So we went through First Amendment in the last video. We're going to go through the other ones, 4th and 5th and 6th and 8th, and then 2nd here. So defendant's rights. What does this mean? When you are arrested, you are a defendant, and you are being charged by the state or by the government, by the federal government, because you have broken the law. And even though you have broken the law, you are entitled, you are given inalienable rights, and each citizen will be given these same rights when they are arrested. Now, does that actually happen? I mean, in theory, right? But it is not perfect. And so when you talk about making sure defendants have their rights to defend the defendant's rights, it's taken a lot of selective incorporation to make sure that this has happened. So defendant's rights are really most of the amendments. So today, your protections when you get arrested come from the 4th, the 5th, the 6th, the 8th Amendments, a little bit from the 7th Amendment, but really 4, 5, 6, and 8. And a lot of the language in the Bill of Rights is so vague. And so a lot of these rights that you have today, things like your ability to remain silent, you can speak to your attorney, you're given an attorney if you cannot afford one by the state, things like that. And, a lot of it is not well defined, so it took Supreme Court cases to incorporate defendant rights written in the Bill of Rights to apply to all 50 states. So remember, when it is incorporated by the 14th Amendment, it's not just the 14th Amendment, it is the Due Process Clause of the 14th Amendment. We're going to talk about another component of the 14th Amendment, the Equal Protection Clause, later. But whenever you talk about selective incorporation, you need to talk about the Due Process Clause of the 14th Amendment. So some examples. Fourth Amendment. Fourth Amendment talks about this idea of unreasonable search and seizures are forbidden by the federal government. And so, yes, the government can search your property. They can seize things for evidence, but they can only do so if it is reasonable. So they need probable cause, or they need a search warrant that has been signed by a judge that allows the police to go into your property. And so basically, you can't have a search warrant without probable cause. There are issues with this. You talk about things like no-knock warrants and things of that nature. But, going into the 14th Amendment, you have this reasonable right to privacy to live your life without the government intervening. That's a civil liberty. And so the Fourth Amendment talks about this principle, and they talk about called the exclusionary rule, which means that if the cops find something illegal in your property, in your car, or in your home, but they got it without a warrant or they got it without probable cause, they're not allowed to use that in a court of law. So perhaps the cops find a murder weapon, but if they didn't get it with a warrant, they cannot use that murder weapon against you and you will likely go free. And so it's the idea that as long as the evidence is collected legally, it can be used against you, but this is for your protection as a citizen. Oh yeah, here you go. Exclusionary rule. So in Mapp v. Ohio, this is a court case that outlines this, is the exclusionary rule needs to be utilized to protect citizens. And this is really so, evidence cannot be planted and things like that. Oftentimes people say, well, the exclusionary rule, this, Fourth Amendment that allows you to get off even if you're guilty because the protocols of following the court case weren't followed is not a good thing. It's maybe a fair critique. But understand, the principle here is that if you are arrested, you are given the freedom of evidence against you must be taken legally. And if it is not, you could potentially be set free. Okay, now, when you are, taken away, it's supporters would say it's not a technicality. It is your right because you are considered innocent until proven guilty. Now, this is not explicitly in the Constitution, but the principle of innocent until proven guilty, definitely a concept in the 1700s. And so this is something that is carried on into the United States. And so this idea that you are innocent until they prove you guilty would say you didn't actually murder that person with that weapon. You are innocent until they confirm that you murdered that person under the law. And while that person might be dead, it may not be technically your fault under the law, which I know can get kind of conflated here. Okay. So other issues. There are warrantless searches, but understand that when we're talking about everyone treated equally, everyone who is arrested is treated the same is not accurate. It should be, but it is not the reality. And so understand that, social justice reform oftentimes revolves around the Fourth Amendment with finding relevant material, getting into people's homes. You talk about the death of Breonna Taylor and, a lot of the issues behind warrants and what evidence can and cannot be used. All of this deals with the freedoms within the Fourth Amendment. Then there's the Fifth Amendment. So a lot of it, there's a lot in the Fifth Amendment, but one component is the self-incrimination component, right? You do not need to speak if it will incriminate you. So you would say, I invoke my Fifth Amendment right as afforded to me by the Constitution against self-incrimination, and then you do not speak, right? So the burden of proof, and this is what we talk about how the courts work, criminal courts work in the United States. The burden of proof lies on the police and the prosecution. It is the job of the government and the police to prove that you committed the crime. The defendant, the person charged with the crime, merely needs to defend themselves and show that there is, not enough to prove without a doubt that someone committed a crime. So the burden of proof lies with the police. And then the other thing, too, is that suspects must testify if the government gives them immunity. And so basically, you would say in court that you committed illegal acts, but the government is giving you a pass. They're saying you can say those things that you did illegally, but you will not go to jail for it either. And so Fifth Amendment provides these issues of who do you have to tell and what, and where the burden of proof is. Again, protecting someone if they're arrested. Another thing with the Fifth Amendment, which a lot of you guys have probably heard of, is your Miranda rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. And these rights come from a 1966 case, Miranda versus Arizona. Ernesto Miranda, understand, was guilty of a crime, but he claims was not read his rights and did not understand. So he spoke to the police because he did not understand the freedoms that he had. And so the Miranda rights are you have to be what's called Mirandized. If you are arrested and they do not read you your rights, you will be let free on a technicality. And so if you ask the defendant if they want a lawyer and they say, yes, I want a lawyer, that interview is over. And anything that is spoken in that interview cannot be used in a court of law. And so these are the rights, again, just more and more examples of how people are protected from the government when they are arrested. So part one of the Sixth Amendment is looking at your right to counsel, your right to a lawyer. You get a lawyer no matter what crime is committed, a federal crime, a state crime, a local crime, every single crime, you get a lawyer. In the 60s, this was not always the case. So Gideon here was arrested because he committed a state crime in in Florida. And in Florida, the state crime that he committed did not give him a lawyer because that wasn't the law. You only get a lawyer if it's a federal crime. And so he lost. He had to defend himself. He didn't know what he was doing, and he went to jail. And Gideon appealed to the Supreme Court and said to the Supreme Court, if I had had a lawyer, I would not have been found guilty. And so now, anytime a crime is committed, doesn't matter if it's a federal crime, state crime, local crime, every single American is afforded a lawyer. And if you can't afford one, the state will pay for one in any case. The other part of the Sixth Amendment deals with your right to a speedy trial and an impartial jury. So if you are arrested, you are entitled to a speedy trial and given a jury of your peers that has not known about the case. Now, this becomes difficult with public opinion and things with, how quickly the media and the press's ability to cover. But understand that most cases don't even make it to the courthouse, and, most of it comes from a plea bargain. So you cop to the charge, you admit that you are guilty to a lesser charge, and then you're given a lesser crime. But that's how most of it goes. And so what we do look at is there's no set size for juries, but you have to be given an impartial jury. Most are 12. It is a unanimous decision. But sometimes there are exceptions. And so if you've seen the movie 12 Angry Men, which is great, kind of shows the process of having to have this unanimous vote. And so really, Sixth Amendment gives you your jury, and you get a trial. It may be settled outside of court, but these two things are afforded in the Sixth Amendment. So Sixth Amendment really has three things: lawyer, speedy trial, impartial jury. Now, what gives you this, the ability to have a speedy trial, is known as the writ of habeas corpus. So meaning to say, if you were to be thrown in jail and not given a trial, there would be no habeas corpus. So when Lincoln was president and people spoke out against the Civil War, he put them in jail and he suspended habeas corpus. They would have been given a trial after the war was over. But because they were not told why they were thrown in jail or even how long they were thrown in jail until their trial, that would be against the Sixth Amendment. But because it wasn't incorporated, even the federal government violating it, during times of war, it gets a little iffy. But habeas corpus, this you would say with, one more example, Guantanamo Bay. Guantanamo Bay is in Cuba. Even though it is a prison that is controlled by the United States, those that are sent to Guantanamo Bay are not given the writ of habeas corpus. This is also why the prison is in Cuba and not in the United States, because if you arrest suspected terrorists and send them to the United States on American soil, they would have to be given this writ to habeas corpus, even as a non-citizen. A couple more things. Eighth Amendment forbids against cruel and unusual punishment. We don't know exactly what that means. Hanging has been ruled cruel and unusual. Some states can use the firing squad, but most, if they do have it, if states do have this type of punishment, it's lethal injection. The electric chair was used in the past, and kind of a yikes type of thing. But the idea is that the federal government is allowed to create punishments so long as they are not cruel and unusual. And this really brings us to the debate over the death penalty. And so it has been ruled that the states are allowed to decide the death penalty on their own, so long as it is not cruel and unusual. And specifically, when you talk about incorporating a court case, you need to know for the AP test, Greg v. Georgia, the death penalty is okay as long as it is suitable to the extreme nature of the crime. But it remains a debate whether or not the death penalty truly is cruel and unusual. Another thing, really a Fourth Amendment issue, but kind of transcends the amendments, is this right to privacy, specifically like the right to privacy with the right to receive an abortion without the government saying it is, ruling on the morality of the abortion. Yes, you can receive an abortion, or no, you cannot. Whose decision is that, right? And so this right to privacy, just like you would have privacy within your property, privacy within your own body. And so a lot of what we talk about now with that really is like the abortion issues with Roe v. Wade. But some say, that this right to privacy isn't actually in the Constitution when it comes to something like, a right to privacy here. So with abortion, there's been a range of different policies at the state level, and state to state, differ with different things like in vitro fertilization, definitions of like the different terms of abortion and cutoff weeks, and really all of these, even things like euthanasia. You are terminally ill from a sickness, and you want to die, and you can get a doctor to sign off on it, right? Is that your right to privacy, to safely go about this like assisted suicide? Very difficult issues to discuss, and really difficult for the courts to define and to enforce. So Roe v. Wade officially, definitely a case you need to know, forbids the state from preventing abortions during the first trimester of a pregnancy. If the state or the federal government wants to step in and prevent an abortion from happening in the second trimester and third trimester, there is some leeway in their ability there. But based on a woman's right to privacy as afforded to her by the Fourth Amendment and others embedded, kind of like holistic, the state, the government cannot intervene. You have a right to live your life, in this case, choose to get an abortion, and the government cannot prevent you from doing that. Now, the government did ban in the third trimester unless it's to save the mother's life. And so this is something that is hotly contested today. If this is overturned, there's discussions of overturning the precedent in Roe v. Wade. What does that mean? It doesn't mean that abortion is illegal. It means that any state that wants to restrict a procedure in the first trimester would then be allowed to do so. So if Alabama, after Roe v. Wade is overturned, if Alabama wants to make a law that prevents abortion in the first trimester, they could do so. Right now, they cannot, because Roe v. Wade prevents them from doing so. And the last thing, understand that some of the Bill of Rights don't even apply to the states. So like the Third Amendment about quartering of soldiers didn't really become a factor, has not been incorporated. So the state of California wants to make a law that allows soldiers to live in your house and you have to let them in, they technically could do so. But one thing that we've seen is, really 20th century, First Amendment is incorporated. 1960s, 1970s, the Warren and Burger courts bringing a lot of the defendants' rights. But we haven't really seen the Second Amendment up until more recently. And so your ability to own a firearm and the ability of the government to step in is limited. And so specifically, you need to know Chicago versus McDonald. Chicago in the early 2000s is the murder capital of the United States, the highest murder per capita, and most of these murders are being committed with handguns. So the city of Chicago steps in, and they create a law that says that they are going to limit the sale of handguns in an attempt to improve safety and limit the number of murders, lower the number of murders in Chicago. Well, the Supreme Court stepped in and said you can't do that. Okay, you can't specifically step in because that would infringe upon the Second Amendment. And so you would say that the Second Amendment has been partially incorporated, and so no state could explicitly prevent handguns, would be one example. Okay, lots of freedoms, lots of things to go over. If you have any questions, please let me know.